Hello, everybody. My name is TJ Scott or Timothy Scott. I'm an estate planning attorney and the owner of the law office of Timothy J. Scott. And I'm so happy to have you here with me this evening. We are having beautiful weather here in Minnesota right now. And I am so happy that you decided to join me this evening and educate yourself about this topic. I know that what we're going to talk about today is a difficult topic. We're talking about the end of our life. We're talking about possibly incapacity before the end of our life. I know that it's difficult to think about these things and it's difficult to talk about these things, but I also believe that knowledge is power. And today I want to empower you, I want to educate you, and I want to give you some peace of mind around end of life topics so that you have the information, you have the knowledge, and you can have a little bit of peace of mind around it. So today I have a ton of valuable information that I want to share with you, and I have some valuable offers that I'm going to be sharing at the end of the presentation. So I hope that you'll stick around and get a great estate plan in place. Let's dive in. You've reserved this time to be here with me tonight. And I just want to say the best way to learn here tonight is to be present with me. That you've dedicated this time. You have set it aside so that you can be at this free class and learn this information. And so I just encourage you to turn off any distractions that you have. If you have the TV on, if you have something going in a different tab, I encourage you to just turn it off for this hour. Give yourself this time that you've already set aside. And as I always like to say, your future self is really going to be glad that you took the time here to learn about this topic. I have a ton of information. You're going to come away knowing more than 95% of your friends and family. And I want to share this information with you so that you have it. And again, if you stick around until the end, I have some great offers that I want to make you. The first offer is how you can talk to me in a free virtual one-on-one meeting where we can talk about the things that you have and the people that you love and how you can protect them. Plus, I want to give you a bonus gift that's going to make it even easier to get a personalized and tailored estate plan in place. But first, before we get to that, I want to ask you a question, and I've got to find my polls button. And the first question that I have is, do you have an estate plan? And the things that I have listed on this slide are all parts of an estate plan. They're all elements of an estate plan. So a trust is often an element that's included in an estate plan, and we'll talk specifically about trust and revocable trust tonight. A will is often part of an estate plan. Guardianship nominations, if you have minor kids, is a pretty necessary part of an estate plan. Healthcare directive, power of attorney, those govern what happens during your lifetime, who can make healthcare decisions for you, who can make financial decisions for you, and then beneficiary designations. And beneficiary designations are an important part of your estate plan as well. I'm seeing overwhelmingly that people do not have an estate plan in place currently, and that isn't really surprising. In fact, there are, let me see if I can share this here even. Good. In fact, something, the majority of Americans don't have an estate plan in place. I think it's something like 69% of Americans don't have an estate plan in place. So don't feel guilty, don't feel embarrassed. You are here tonight and we can remedy that. We can take steps to remedy that right away. So if you don't have an estate plan in place, why don't you have an estate plan in place? Maybe one of these things resonates, or maybe multiple of these things resonate with you. Maybe you're too busy. And trust me, as a father of 4 young kids, life is really busy. I totally get it. But again, if that's the case for you, I want to commend you on being here tonight and taking some time to learn about this and to take the first step forward in getting an estate plan done and getting it taken care of. I can promise you, I make it a very simple process to get an estate plan done for my clients. I take away a lot of the work that they would have to do otherwise. I'm able to speak with them for a couple of hours in order to get at what they want to do and get it done for them. Maybe you feel like you're too young. And again, I totally understand that. I know I look pretty young. I feel pretty young most of the time. But really, anyone over the age of 18 should have an estate plan in place. I recently helped a young family where a young father had passed away. And unfortunately, he left kind of a mess behind for his wife and minor daughters. But that doesn't have to be the case. I've helped young people, especially young families, and I've seen the look of relief on their face when they get a plan in place and they know that their loved ones are going to be taken care of. Maybe you're worried about this being too expensive. And I do see that some people are sharing, they're worried that it's going to be too expensive to get this done. And I'll tell you, before word processing, estate planning really was just for the wealthy. But today, estate planning is for everybody. Everyone can afford to get a great estate plan in place. And again, I've got some great bonuses that I'm going to offer at the end so that it will be even more affordable to get a great estate plan in place. Let me go ahead and share this really quickly. And maybe you're worried about jinxing yourself. And I don't see anybody offering that they're worried about jinxing themselves, but I completely understand if you are. I've heard that from a lot of people. And the good news is I've written a lot of estate plans for a lot of people, and I've never seen a correlation between getting an estate plan done and having something bad happen to them. It is a Hollywood fiction that the police officer on his last week on the job has something happen, or somebody who just gets their estate plan done has something happen. So rest easy. You don't have to worry about jinxing yourselves. I see here somebody saying, didn't realize there were that many different aspects, don't have an estate, but we do have children. Yeah. So there are a lot of different elements of an estate plan, and I'll talk about all of them tonight. I'll talk about what they all mean. And I see somebody who wasn't sure that they were going to be able to join, was able to join. I'm really glad to have you on the call. I'm glad that you're able to make it here. All right. Let's see. All right. If you have a plan in place, what do you want to learn here tonight? And I don't think that there was anybody who was saying that they have a plan in place currently, but maybe something on this list resonates with you. Maybe you are thinking about doing an online will, or you've done an online will, and you want to know if that's okay, if that's going to take care of your family. Or maybe you did an estate plan, but it was 10 or 15 or 20 years ago, and you're wondering if it's outdated. Has anything changed in your life, or has anything changed in the law in such a way that it makes sense to redo or update that estate plan? And maybe you just want to get a better understanding of an estate plan that you worked on a long time ago, or even just recently. I know not all attorneys have the same emphasis on educating and empowering their clients. And so a lot of times people are just confused about, what did I just sign? What does it mean? What's going to happen with my family? Post in the chat if you have something specific that, or some specific question that you were hoping to get an answer to today. I want to see it. Either post it in the chat or post it in the Q&A, and I'll make sure that we spend some time and address those questions that I get. I see here, what's the worst situation that will happen if you don't have a plan in place? And that's a very good question. I would say that the worst situation that could happen is that the people you want to receive your assets aren't able to. I would say that that's a pretty bad situation. And so there are what's called intestate statutes in Minnesota. So Minnesota guesses at who you would want to have receive your assets. And I would say it's right for most people. It's right for about 80% of people, but it's not right for everybody. And it is a bad situation if the intestate statutes aren't right for you, and somebody you wouldn't want receiving your assets ends up getting to receive the assets. So that's a bad situation. Maybe even a worse situation is conflict in the family. And that is something that I have seen a lot as an estate planning attorney who's cleaning up after other estate planning attorneys, that oftentimes not having a plan in place or having an inappropriate plan in place can lead to conflict in the family and can lead to infighting, and ends up having a situation where the family can even just dissolve and no longer, brother doesn't want to talk to sister anymore. And that is such a nightmare. Really, that's one of the big reasons that I got into estate planning, is to avoid those kinds of family conflicts and to make sure that that the family is taken care of. Costliness. That's another thing that that might happen from not having a plan in place, is it can cost a lot of money from the estate. It can also cost a lot of time for the beneficiaries and for the fiduciaries who are trying to wrap up the estate. And we'll talk about all of those things here tonight. That's a fantastic question. If there are other questions, again, I hope you'll put them either in the chat or the Q&A. Oh, and I do see somebody here. My mother has a will, just my sister and I. Our names are on the house, checks, bank account, investments. Will this keep us out of probate? That's a really fantastic question. I am going to spend a lot of time talking about probate tonight and talking about what it is and why you might want to avoid it. Probate, you can stay out of probate as long as the assets that are in your personal name don't include any real estate and have a total value of less than $75,000. So if you don't have any real estate, and this is true just here in Minnesota, but if you don't have any real estate in your personal name, and if you have less than $75,000, then there's a simpler procedure that you can use in order to avoid probate. And so we'll talk a little bit about that. I would have to know more about your mom's situation in order to really answer that in detail and answer it in the specifics. And if you want me to, I'd be happy to have a meeting with your mom where we review her assets and we review the will that she currently has. And we take a look at it and make sure that everything's set up the way that she wants it to be set up. Planning with a will means that you're going to have to go into probate. So if your name is on the house, means that the house is given over to you in the will, then unfortunately that will is going to have to go into the probate court and be probated in order to get through to you and your sister. But I was taking that to mean that your names are on the house, meaning something like a transfer on death deed or joint ownership, something like that. And if that's the case, then it would just go to you by operation of law when your mom passes away. All right. What should you consider if you own a business that generates a lot of income? Now, that's a fantastic question. One of the things that you want to consider is who can step into your shoes and continue to operate that business when you're gone. And so if you are relying on a will, or if you don't have any estate plan in place at all, then it's going to be really hard to get somebody who can stand in your shoes and continue that business after you've passed away. Unfortunately, the probate system just takes a lot of time. It takes a lot of effort in order to get somebody approved and somebody appointed who can actually step into your shoes and run the business for you after you're gone. So I will offer an alternative that I would recommend. The alternative is having a living trust or a revocable trust that actually owns the business, or that you put your interest of the business in. You still have complete control over it, but when something happens to you, the successor trustee can step into your shoes right away and continue running the business and continue operating the business. Good question. I'm particularly concerned about my deceased wife's ex-husband coming after me for money. In his opinion, the $250,000 she left to her daughters is not enough. That is a tough situation. Again, I hope that you'll reach out to me and we can talk about that situation in more specifics. It's hard to address here, not having all the specifics and wanting to maintain some privacy as well. So I hope that you'll reach out to me. I'm also concerned that my ex-wife will try to raid my estate through our children, 19 and 14, and that those kids have been poisoned against you. That is devastating. That is, I'm really sorry to hear that you're in this situation. And again, I hope that you'll reach out to me. There are things that we can do to protect that money that are in your estate. There are things that we can do to protect your inheritance from your wife. And we can talk about that. And I see here somebody saying, won't joint tenancy prevent that? You just answered it. Yes, that's exactly right. Joint tenancy operates by operation of law. It transfers title to that person who's the joint tenant on the property when the other joint tenant passes away. Great question. Great contribution there. So, are you in the right place here tonight? Yes, you're in the right place if you have someone or something that you care about and that you want to protect. And you're in the right place if you did an online or fill in the blank will, but you're not sure if it's going to work for your family and work for the people that you love. And you're in the right place if you're nervous about how much this is going to cost. Again, as a father of 4 young kids, I completely understand it, and I'm sensitive to cost myself. And we'll talk about how you can get a great estate plan in place without a lot of extra expense and without a lot of extra cost. I see somebody else. An issue I see with the Minnesota guessing game is my mom just passed. She's married. She was his guardian. Everything goes to him. He does not have a will, and Minnesota guessing game gives everything to his family. Yeah, siblings. because I am not adopted by him, regardless that they were married for almost 20 years and the land was hers before they were married. She had no will either. Yeah, that is a very sad state of affairs. And there should be some things as the adult, I'm assuming that you're an adult child of your mother, there were certain things that maybe you could have claimed when your mom passed away, but it's not very much. It's a little bit of personal property and it's a vehicle. It's just not very much. It's not enough. And unfortunately, when people die out of order like that, or don't have an estate plan in place that dictates what's going to happen after the second of them pass away, it can leave the kids from the deceased spouse out in the cold, and that's a really sad state of affairs. But unfortunately, that can be the case. But I hope that you'll reach out to me, because there might be some additional ways that you can access some of that inheritance, and we can talk about that. And I do see here we did have joint tenancy on our home, thank God. Otherwise, that would be a lever for ex-husband to force me out of my house. Yeah, that's right. That's right. I'm glad that you had joint tenancy. So the reality is, estate planning is not about us. And this is something that really occurred to my wife and I when we were updating our estate plan recently. Our estate plan isn't going to bring us extra wealth. It's not like a business. It's not like owning, and operating a business or something like that. We're doing it for the people that we love and the people who come after us, and to make things easy for them, especially at a time when they're grieving and things shouldn't be difficult for them. It's really about those people that we love. And your loved ones are going to know whether you lived up to your promise to take care of it after you're gone. And you can take care of it. You can take care of it in an affordable way and without taking up a lot of your time. And I'm going to tell you how you can do that here tonight. So what am I going to cover here today? I'm going to cover a lot of things. We're going to talk about estate planning, from planning for incapacity to planning for when you pass away. I'm going to put up one last poll here, because I kind of want to get a picture of where people are coming from. If you could tell me which of these best describes you. But planning for incapacity means who can make healthcare decisions for you, who can make financial decisions for you. If you're in a coma or if you're suffering from dementia, who are those people who can make those decisions for you? And once you've passed away, planning for things like guardianship if you have minor kids. And that's really the biggest reason that I want to ask this poll question, is to see how many people there are with young kids, so that we can talk about that. We're also going to talk about probate. We're going to talk about the time, cost, and public nature of probate and what that means for you and for your family. We're going to talk about estate taxes tonight. We're going to talk about unclaimed property. We're going to talk about how your intangible assets can transfer to your next generation, not just your tangible assets. All right, I see here I don't fit any of those categories. Widowed with 4 kids, one of whom is still a minor. Yeah, that's kind of a combination, but there's an element of young kids there. Thank you for sharing that with me. And I see here we have 4 adult children and 2 minor children. Well, you have been blessed. That sounds like a beautiful big family. So congratulations, and I'll keep that in mind as we're talking here as well. This is my family, and as you can see, it's my wife and I. My wife's name is Tobin, and we have 4 kids now. Just about a little over 2 months ago, we welcomed our 4th. And so from oldest to youngest, we have Benjamin, Elizabeth, Margaret, and then the baby in arms is Bridget, and we are the Scotts. And my family is my whole world. And we live here in Bloomington, Minnesota. Again, we just moved to this city from St. Paul, which is where we were up until 2019. So I graduated from the University of St. Thomas School of Law in 2012, near the top of my class. And the very next day, my first child, Ben, was born. I found a job with a small estate planning and tax preparation law firm, and I loved the clients that I was able to work with, but sometimes I didn't feel like I was providing the level of value that my clients deserved. And so a little after 3 years at the firm, I ended up leaving. This is actually a picture from my last day there. Someone has to graduate at the bottom of the class. Now, I have to say this was not said about me, but this is something that I remember my parents saying about an extremely negative experience they had with an estate planning attorney who helped my grandmother. And I remember my mom saying this, someone has to graduate at the bottom of the class. And there was a big reason for that. I actually don't think that it was this attorney's knowledge, but I think it was the model that this attorney was practicing under. I'll talk about that faulty model. I call it planning for death a little bit later, but first, let's talk about some of the aspects of estate planning. And so I know not everybody here tonight has minor kids, but I'm seeing enough people with minor kids that I want to address this at least briefly. Guardianship is very important if you have a child under the age of 18. And there are a couple of different aspects of guardianship. There's short-term guardianship, which covers what happens if mom and dad don't come home. What happens if the kids are with a babysitter, mom and dad are out on a date night, there's a car accident, mom and dad don't come home. Well, if there's no plan in place, the police are going to be called and Child Protective Services will be brought in to keep those kids. It's just the least liability for the police to have that situation, to have the kids with Child Protective Services. And that's why it's so important to get a plan in place so that there's some short-term guardian and there's some legal documentation about who those kids can stay with if the worst happens on a date night. There's also long-term guardianship. And long-term guardianship is who is going to raise your kids until the age of 18. And if you don't have a plan in place, unfortunately, there is a plan for you. And that plan is that a judge is going to decide who the best person is to raise your kids. And if the best person in the judge's opinion is Uncle Larry, even though you know Uncle Larry should never have custody of your kids, should never be raising your kids until the age of 18. Well, if the judge decides that Uncle Larry is the right person, then Uncle Larry is going to end up with the kids. And that's why it's so important to get both elements in place, short-term guardianship and long-term guardianship if you have minor children. All right, now let's talk about how the people that you love will receive your assets under your current plan or under the state's plan for you. And the state does have an estate plan for you. The state's estate plan for you is a court process called probate. And probate is a lawsuit that you file against yourself with your own money for the benefit of your creditors after you've passed away. In order to get somebody who can stand in your shoes and do things like transfer your assets and distribute them out, in order to decide where those assets are going to go, if you don't have a plan in place, or if you've planned with a will, then you're looking at this process called probate. And again, it's a court case. It can lead to a lot of conflict in the family, especially if there isn't even a will in place about who is going to be the person responsible for making sure that everything gets where it's supposed to go, who's going to be the person responsible for paying the creditors. Probate is expensive. Probate costs something like 3 to 6% of the gross value of the estate. And that's not a perfect number, it's just an estimate that we have. And the reason that it's an estimate is because the fees and the expenses are, they change from estate to estate. It's not a fixed number that we can apply, but there are all these different fees, attorney's fees and executor's fees, appraiser's fees and bond premiums, filing fees. There are all kinds of different fees that you're looking at paying. So you can imagine from a cost perspective, if all that you own is a house that's worth $400,000, and I recognize that's a pretty nice house, but if all that you have is that one asset, that house that's worth $400,000, probate is already probably going to cost something between $12,000 and $24,000 to get through that process. It's expensive, and that's money that is coming out of your inheritance that you really want to leave to your kids or to your loved ones, not money that you want going to a court process that your family is going to have to go through. Probate's also slow. In Minnesota, it takes a minimum of 6 to 12 months to get through the probate process. We'd like it to go faster, but it just can't. Oftentimes these days, it's taking up to 18 months to get through the probate process, sometimes even longer. I think Prince's estate is still going through the probate process. It is just a very slow process. And as far as the actual calculations for what your probate estate might cost going through this process, we'll actually have a chance in just a little bit to calculate what that 3 to 6% might look like for you. Probate is also public. So I'm showing you here the last will and testament of Anna Nicole Smith. Wills are totally public. They have to be filed with the court, and the court has a policy of transparency. So you can go to the court and access people's will. You can access documents like an inventory and a final accounting and a plan of distribution for any probate out there. And this puts creditors on notice, unfortunately, that loved ones might be receiving money. And unfortunately, there are bad people out there who can access this information and approach your heirs and the people that you love, knowing that they're going to have extra money that's coming to them. If your kids are below the age of 18 or whatever the age that they're at, they're likely to receive the money from the probate outright and unprotected. And this is, I think we all know stories about people who received money at too young of an age and how it can kind of spoil people. It can cause people to choose not to get educated, or it can spoil people to choose not to work hard, and they can just rest on that money. And unfortunately, when that money is gone, they don't have the good habits of educating themselves. They don't have the good habits of working hard that so many of us have developed over our lifetime, and that we've put into creating the wealth that we have in our own lives. So here's your chance to calculate your probate estate. And this is a sample probate estate that I have listed here. Here you can see I have a family home, and that's the fair market value. I have a rental property. I have some furniture and household goods. I have some automobiles. I have some stocks, bonds, and bank accounts. And I also have some business interests listed there as well. And all of those things are things that generally don't pass by beneficiary designation. They generally pass through an estate in the probate process. And you can see here that the total for all of those assets is $850,000. But you can get 5% of your number, whatever your number is, very quickly by moving the comma over one place to the left and then dividing that number in half. And that's how you get 5%, which is neatly between the 3 to 6% that probate generally costs. So here you can see that the estimated probate costs and fees would be something like $42,500. And this might be slightly elevated, but it is an illustration of the kinds of costs and the kinds of fees that you can expect. In fact, it might not even be elevated, especially since there are business interests implicated and two properties that need to get sold. This might be pretty accurate, especially if you think about that family home is going to remain vacant. And if there's a mortgage on it, the mortgage is going to need to get paid. If there are real estate taxes, the real estate taxes need to get paid. Utilities need to get paid. So a lot of costs can continue to run while that family home remains vacant. And it might be true with the rental property too, if they don't have another renter in there. Just to add a little wrinkle, if you have life insurance or retirement accounts that are payable to a minor, and many of us have put minors as beneficiaries on our retirement accounts or on life insurance policies, it's not good to do, because those monies that they should be receiving are going to have to go through a process. They're going to have to go through the probate process and then through a process called conservatorship. And here you can see how that really balloons the estimated probate costs and fees, because those things would be payable to a minor. Now, the good news is that there's a foolproof way to avoid probate, and that's by fully funding a living trust. And I'm going to talk here a little bit about what a trust is. A trust is an agreement between two parties. That's the simplest thing, the simplest way to describe a trust. And it's an agreement between two parties that one party starts with the property and they give that party, or they give that property over to the other party. And then they set up some rules for that party, and this party says, yes, I will follow your rules regarding this property, okay? So one party starts with the property, they give it to another party, and the party that started with the property says, follow these rules about that property. Use that property in this way. And this person says, yes, I will follow your rules. I will take care of the property in the way that you asked me to. So this person is called the settlor. The person who started with the property is called the settlor or the grantor or the creator or the trustor. There are all kinds of different names for it, but settlor is what's most commonly used here in Minnesota. And they're the one giving the property over to the person with control over the property now, who's called the trustee. That's the person with the control over the property. And the cool thing about a living trust is you would be both the settlor, the person creating the trust and writing the rules, and you would be the person with control, the trustee as well, who has all of the control to use the assets for what you want to use them for. But it's very important that this transfer happens. So, for example, if you have an investment account, you need to retitle that investment account so that it goes to the trustee. And if you have bank accounts, and we all have bank accounts, you need to go to the bank and sign new signature cards so that they get to the trustee and they're in the name of the trust. If you have a home, if you own real property, you need to sign a deed over to your trustee and to your trust so that that real property is in your trust. The same thing with stock and bond certificates. You transfer those to your trustee and into the name of your trust. You assign personal property into your trust, and you change life insurance and retirement account beneficiary designations so that they pay directly to the trust instead of paying out to somebody else or having to go through the probate process. All right, so that's a lot of talking. This slide has a ton of information on it, and I realize that, but this is something that we can go through in more detail if you want to, if you decide to take me up on the offer to have a one-to-one meeting with me, and we can talk about this in more detail. All right, here I get to give most people here some really good news. We get to calculate your estate taxable estate. But the good news is that even though there's an estate tax at the federal level and an estate tax at the state level, it doesn't apply to most people. So on the federal level, the estate tax rate goes up to 40%, but it only applies to monies above $12.06 million. So it applies to your $12,060,000 and first dollar, and that's where that estate tax rate kicks in. So it doesn't apply to almost anybody because most of us have estates that are below $12 million, right? In Minnesota, we also have an estate tax. The Minnesota estate tax rate goes from 13% to 16%, but it only kicks in when you get assets above $3 million. So there's a little bit lower floor for the Minnesota estate tax, or a little bit lower, I guess it's a floor for the Minnesota estate tax. But again, $3 million is probably more than most people have. In fact, I think that you have to be, in a pretty small minority in order to get above that $3 million. Still, if you have assets in excess of $3 million, if you have assets in excess of $12 million, know that there is some estate tax planning that we can do. And I definitely hope that you'll reach out to me so that we can start some of that estate tax planning and minimize the estate tax burden that your heirs are going to have to pay after you've passed, okay? Will your assets be lost to the state? And this is something that not a lot of estate planning attorneys talk about and not a lot of estate planning attorneys cover, but I think this is so crucial. I know as somebody who's still building my wealth and building the inheritance that I want my kids to receive, that I want them to receive absolutely everything that I have to give them. I don't want anything to be lost to the Minnesota Department of Unclaimed Property. And does anyone have any idea how much money is currently in our State Department of Unclaimed Property? It's a shocking number. There's over $700 million in the Minnesota Department of Unclaimed Property. And across the United States, there's over $58 billion, billion with a B, in state departments of unclaimed property. And a big way that that money gets there is that when somebody passes away, their heirs and their fiduciaries, the people who are supposed to be collecting things and figuring out where things are and where all the different assets are at, their heirs don't know or can't find all of the different assets that their parent had or whoever it was that passed away had. And this can be really, this happens frequently these days with electronic statements turned on. People don't have paper statements coming to the house anymore where the personal representative or the executor can just follow along in the mail and see what's out there and see where you're getting paper statements from. So it's really easy for this money to get lost. But that's why for my clients, I create an inventory for them so that when they pass away, I can tell their heirs and I can tell their executor and personal representative exactly where their assets are and where they're being held so that we can make sure that everything transfers and that everything gets to the people that they want it to get to. Oh, this is really cool. So you can also make your living trust a real treasure chest. And when I say that, I'm talking about building in something called asset protection. Asset protection can protect the inheritance that you want to give to your heirs from things like divorce and things like creditors in a lawsuit or in bankruptcy. This is so cool. It's a gift that kids can't give to themselves, or it's a gift that we can't give to ourselves because you can't fund these things in a first-person way. It has to be a third party who's funding these asset protection trusts in order to really get that asset protection that you're able to get. So again, this is a very cool feature. It's something that it's a gift that you can give to your kids, again, that they really can't give to themselves. And it's something that's really valuable that you can give to them in their inheritance. Excuse me for just a minute here. Okay. So I know this is something that's very present for a lot of us right now, or it's something that a lot of us have maybe had experience with or had concerns about recently, and it's planning for incapacity. Planning for incapacity is extremely important and includes planning for who can make healthcare decisions for you, who can choose where you live, what kind of healthcare decisions you want that person to make. You can tell that person where you want to continue living and where you would be most comfortable living. Also planning for who can make financial decisions for you. For example, who can write checks to cover the mortgage or to cover utilities on your behalf if you become incapacitated, if you're in a coma, or if you're very sick and you can't do these things for yourself, or if you start to suffer from dementia, that who can make these who can make these decisions for you, excuse me. And we have pictured here an individual by the name of Terry Schiavo. And I don't know how many people here remember Terry Schiavo. Maybe put in the chat if you remember who Terry Schiavo is. But Terry Schiavo was a person who suffered a cardiac event and was living in a vegetative state. And there was an argument between her husband and between her parents about what Terry's wishes would be living in that vegetative state. Her husband thought that Terry would not want to continue living in that vegetative state. Her parents thought that Terry was experiencing enough of life that she would want to be kept alive in that state. And I'm seeing a lot of people who remember Terry Schiavo, and that's great. And so because there was this argument between the husband and between the parents, all of these court cases ended up coming out about who was right and who got to decide what was going to happen to Terry, and should Terry be kept on nutrition, and I can't remember. I don't think she was on oxygen. I think she was just on nutrition, or should nutrition be removed and should Terry be permitted to pass away? And there were a ton of fights. There was a ton of conflict. This was in the mid 2000s, and we were all watching kind of in awe about this happening and thinking about how this could be happening and how there could be this large public argument about this, but it didn't have to be that way. You can put in place exactly what kind of healthcare decisions you want for yourself, and you can do that creating something called a healthcare directive that also names the person that you want to make healthcare decisions for you. So we've talked about a lot of things today. We've talked about probate. We've talked about intestate succession. We've talked about planning with a living trust and how beneficial that is to avoid probate for your family, to avoid the cost, to avoid the time, to avoid the public nature of probate. We've talked about incapacity, and we've talked about how important it can be to plan for who can make healthcare decisions for you and what kind of healthcare decisions you want made on your behalf. We've talked about planning for guardianship if you have minor kids, how important it is to not only plan for long-term guardianship, who's going to raise those kids until the age of 18, where are they going to flourish, but also who's going to be immediately available to take those kids so that they don't go into the custody of Child Protective Services. We've talked about a ton of things today. And if anything there has resonated with you, you're probably thinking right now, what can you do today to do the right thing for your family, and what should it cost to plan right? And the options for creating a plan are twofold. You can do it yourself, or you can work with a lawyer. And keep in mind that not all lawyers are the same. So should you do it yourself, would you benefit from working with an attorney? Well, you would likely benefit from working with an attorney if you own more than just your personal belongings, things such as cars, clothing, jewelry, and furnishings. If you own real property, I would say you definitely want to consider working with an attorney. If you own substantial retirement accounts, bank accounts, investment accounts, if you own a business, certainly you definitely want to consider working with an attorney. Things can get very complicated if you own real estate, or if you own more than $75,000 in personal belongings, which we talked about earlier this evening. You'd also benefit from working with a lawyer if you want to ensure that the people you love stay out of court and out of conflict, and have somebody to turn to when something happens to you, a real advisor that they can turn to guide them through the process. If you want the kids protection plan, which includes the short-term guardianship, long-term guardianship, medical powers of attorney for the kids, instructions to guardians, instructions to caregivers, all kinds of great things for your minor children to provide guidance and to make sure that they're secure and that they're taken care of. Or if you want to avoid probate or estate taxes, or if you want to protect your children's inheritance in something like an asset protection trust, then you have to work with a lawyer. Those are things that you need to work with a lawyer in order to get. And if you want to guarantee that your plan is going to work when your family needs it to work, then you really have to work with a lawyer. It's not something you can do yourself. And there's a story that I really like to tell, because I'm a big do-it-yourselfer, but there's a story that I like to tell about a do-it-yourself project that just went off the rails wrong. And here it is. I had gotten new fishing poles and reels for my son and I so that we could go fishing. But when I got the new rods and reels, they didn't have fishing line on them already. So I had to order fishing line separate and put the fishing line on. Not a big deal. I thought that I knew what I was doing, and I checked a YouTube video, so how could it go wrong, right? And I thought I had just finished, and I was reeling up and putting the fishing line on, and I just went to snip the extra fishing line off, and all of a sudden, I don't know what I did, but the fishing line started leaping off of the reel, and there was fishing line all over the place, and it was a huge mess of fishing line. Okay, so that was an example of a do-it-yourself project that just went wrong. But here's the good thing. It was a do-it-yourself project that went wrong, but the cost of that ruined fishing line, that little extra fishing line that had jumped off of the reel, wasn't huge. It wasn't that big of a deal. Maybe it was 30 cents of fishing line, something like that. Number two, I saw immediately that my do-it-yourself project had failed, but I was able to clean it up and take care of it. And because I had that immediate feedback, because I could see that it didn't work, I was able to get everything fixed up, and my son and I were still able to go out fishing that morning. Not a big deal. An estate plan is not like that. An estate plan, if you goof something up, it's not 30 cents of fishing line that you're going to have to be responsible for. It's huge costs of probate, huge costs of lawyers and court fees and all kinds of different things that your family is going to have to pay. Not to mention the conflict that your family might end up in because what you wanted to have happen isn't clear, or because whatever happens wrong with the documents isn't actually what you would want to have happen, and now your family is fighting about the situation. And you're not going to know if your estate plan is going to work or not until after you're gone, and until it's too late to clean up. It's a situation where you can think that you have everything exactly the way that you want it and exactly right, but unfortunately, you're just not going to know. There's no guarantee until after you're gone exactly what your estate plan is going to do. That's why it's so important to work with a professional, to work with somebody who's seen it before, who's written estate plans and executed those estate plans when they need to be executed, and can see the before and after and make sure that your estate plan is really going to work the way that you want it to. And so that's my do-it-yourself story. I don't know if that resonates with anybody, but we have had many successful fishing trips since then. So it's even though it's a failure of a do-it-yourself story, at least we had some success out of it. One added thing, if you want to give your assets to someone other than your kids, it's kind of what happens by default at law, is that your assets would go to your kids. But if you don't have kids, or if you choose not to include all of your kids equally, then you really need to have an attorney help you to draft those provisions to make sure that they go the way that you want it to. So you probably know by now whether you want to work with an attorney or if you feel comfortable trying to go and do it yourself. But again, remember, not all attorneys are the same. And again, I want to bring you back to this quote from my parents: someone has to graduate at the bottom of the class. Again, this was not said about me. This was my parents' experience with an estate planning attorney who helped my grandmother to plan her estate, helped my grandmother. And again, I don't think that he actually graduated at the bottom of the class. I think the frustration was probably with the model that this estate planning attorney was operating under. And I call it planning for death. And this is what the typical experience looks like working with a typical planning for death estate planning attorney. Number one, you're going to get form documents that are kind of set it and forget it. Probably going to put them in the bottom of your desk and never look at them again. And you may not even understand them at the time that you're signing them, because that attorney probably hasn't educated you, probably hasn't empowered you to make the decisions in the estate plan. They've just created these form documents for you, and you've signed them, and you think that you're covered, but you don't really know. Typical experience isn't going to keep money out of the Minnesota Department of Unclaimed Property. It's just not a priority. It's not something that most estate planning attorneys address or consider. Typical experience may avoid probate, but it may not. Typical experience probably doesn't keep the family out of court and out of conflict. It's only going to focus on money and not your intangible assets, things like your stories and your values that are so important, and that oftentimes we would choose even above our assets to give to our kids, those stories and values. Typical plan is going to leave assets to heirs unprotected, that it's not going to have that asset protection built in, which is a great opportunity for inheritance to have that asset protection built in. Typical experience is not going to include ongoing legal guidance. You're going to face hourly fees for any future needs. And those hourly fees set up this situation where you don't really want to call the attorney, and the attorney is nervous to reach out to you because they know that they're going to have to charge you additional hourly fees. Typical experience is also not going to adequately protect minor kids. It might give them protection, it might give them the long-term guardianship, but most estate planning attorneys don't cover short-term guardianship. They don't do medical powers of attorney for kids. They don't take care of a lot of the things that minor kids really need to have. And the worst thing is, you're going to be left with this question: is my plan going to work when I need it to work? And that's not a question you should ever have after working with a professional. Or you can plan with me. And I have a planning system. I call it Planning for Life, which is a totally different experience. Number one, I charge flat fees, and I let my clients choose the fee. And that doesn't mean that I'm just relying on a goodwill offering or anything like that, but I have different fee packages, and I'll work with you to make sure that we choose the fee package and the plan that not only does best by your family, but that fits within your budget and that's economical for you, something that you can afford, and make sure that it fits for you and fits for your family. Planning with me is going to keep your money out of the hands of the state. Like I say, I create inventories for all of my clients to make sure that we have all of their assets collected after they have passed away. And so that's a great resource that I have and that I keep and that I continue to update throughout our relationship together. Planning for life means protecting your kids totally, both their immediate short-term guardianship need and the long-term guardianship need. Planning with me keeps your family out of court and conflict. Again, I'm really passionate about that. At heart, I'm a peacemaker, and I want to keep your family together. I want to make sure that they're not torn apart by arguments and by conflict over your estate plan and over the inheritance that they are set to receive. Planning with me means that you're going to know that you've made the right decisions. I'm going to educate you and I'm going to empower you to make decisions in your plan. I want you to write your plan, and I'm there to educate you and let you know the decisions that you need to make, what they mean, and how you can best make those decisions. Planning with me means protecting the family money from outsiders, that asset protection from things like a divorcing spouse or from creditors in a lawsuit or in a bankruptcy. And planning with me, it means a lifetime of guidance and protection. We can have a relationship together. It's not just a one-time transaction. We can work together into the future and make sure that you are able to keep your estate plan updated and that your family has somebody to turn to after you're gone. And unfortunately, I can't include all of the costs of future plan updates in one flat fee. I just can't, because I don't know what your future holds, and you likely don't know what your future holds, whether it holds more children or grandchildren or great-grandchildren. But I can promise you this, that we will come up with a reasonable fee between the two of us, and it'll be a flat fee. You'll know exactly what it's going to cost to make adjustments to your plans. And I'm not going to charge you for phone calls and emails and questions that you have about your plan. I want to answer all of those and make sure that you know that you can turn to me and ask questions when you need to ask questions, and that you can call me and you can tell me when you have, your first grandchild is born, or if you buy your dream house, your dream cabin somewhere and you've moved there. I want you to feel like you can call me and tell me those things, and I can tell you how it's going to affect your plan. Planning with me means that your plan is going to work when your family needs it to work. And it's really a gift that you're giving to the people that you love the most. I know that this is a question that's on a lot of people's minds, and I want to make sure that we address it here before I offer you the opportunity to schedule a meeting with me. And that question is, what should this cost? What should working with an attorney and planning cost you? And keep in mind that this planning will save your family at least $12,000 if all that you have is a house that's worth $400,000. Again, acknowledging that that's a pretty nice house for many of us. For many of us, we own a house that may even be more than that. But keep in mind that that's 3%. That's the low value of what a probate would cost. 3% of a $400,000 house is $12,000. And if you have assets over $3 million, then this planning is going to save your family at least 13 cents on the dollar for every dollar in excess of $3 million. The typical death plan with a typical estate planning attorney is going to cost a minimum of $1,500. You're just not going to be able to find a typical estate planning attorney who's able to do it for less than that. They're probably going to charge you an hourly fee, and they're probably going to be opaque about what that hourly fee, what the total amount or what the total estimate is going to be. But you can expect to pay at least $1,500 with a typical estate planning attorney. And you can almost guarantee that it's not going to keep your family out of court and out of conflict. It's probably not going to ensure your assets are not lost to the State Department of Unclaimed Property. It's only going to cover your money, not your intangible assets. And it's not going to cover your kids' immediate care. It's just going to leave you and leave your family short when your family needs to be covered the most. Or alternatively, you can plan with me. I'm a personal family lawyer, and you can learn specifically what your family needs. You can choose your own fee, likely to range somewhere between $2,000 and $8,000. And you're going to know that your plan is going to work for your family when your family needs it to work for them. And again, I want to make this super simple. And I'm actually going to come here and post for everybody to see the link to my scheduling page. Excuse me. Now on that scheduling page, you can see where I offer a family wealth planning session. And that family wealth planning session is a 2-hour-long working session with me where we can meet virtually, we can meet over Zoom, and we'll talk about everything that you have and everyone that you love. and I'll get you very clear on exactly what would happen under your current plan, what would happen under the state's plan for you, or if you have a will in place or if you have a trust in place. I can analyze those, and I can tell you exactly what would happen under your current plan. And I want to offer you that family wealth planning session, that 2-hour-long session, to you for completely free, just for attending here with me today. And I really, the only thing that I want you to do ahead of time is a little bit of pre-work. There's a little bit of homework that I want you to do. It's a form, and I'll send it out to you. It's an online form that I just ask you to fill in order to make our meeting as productive as possible. But I really want to give that to you at no charge, because I want you to have the information. I want to educate you, and I want to empower you. If there are changes to the current plan, if there are changes to the state's plan for you, or the estate plan that you've had written before, or the online will that you've done, or whatever the case is, I want you to have the power to change that plan and to turn it into something that's going to serve your family in a really good way after you're gone. I also want to give you $250 off the estate planning fee, the estate planning package of your choice, if you'll reserve your appointment by the end of the week. And when I say the end of the week, I mean the end of the day Saturday. Now, why do I limit it like that? Why do I say that you have to book your appointment by the end of the day Saturday? And it doesn't have to be, you don't have to have your appointment before the end of the day Saturday, but you have to be on my calendar by the end of the day Saturday. And the reason that I limit it like that is because this is a momentum thing. Estate planning is something that can fall to the bottom of our to-do list all too easily. And I often need to follow up with people and continually follow up with people and ask them, I don't see you on my calendar yet. How can I get you on my calendar? When are you going to make this a priority so that you can take the next step and get this done? And there's a cost associated with that, with needing to do that follow-up. And that's why I say, if you will book your appointment here by the end of the week, I'm happy to give you $250 off of the plan of your choice. I see somebody saying booked. That's awesome. I see somebody asking, do you have a plan for a situation? Should you pass, what will happen to our plans when we need to make changes? Thank you so much for today. It was very insightful. Great. I'm glad to hear that. Yeah, so I have I plan for people for when they pass, and we can go through that, and we can take a look at exactly what the situation will be and how we plan for it. And there are changes that, it often happens that there are changes in the family, there are changes in the assets, there are changes in the law that mean that there need to be changes to your plan in the future. And again, when that happens, if there's a change that actually needs to occur in a document, I'll work with you. We'll agree on a reasonable fee to make that change. And we have word processing, features today that make it pretty easy to implement minor changes. Things like adding a new child, or adding, making a small change to one of your fiduciaries, like a trustee or who's serving as your healthcare agent, something like that. I can make those changes pretty inexpensively, and I will do that pretty inexpensively for you. But if the changes are more advanced and if they're more intensive, then we'll just work together on what a reasonable fee is. I'm really happy to see that people are booking already. So these are your next steps. Schedule your family wealth planning session with me. Again, it is a free meeting, and I want to give it to you so that you have the information, so that you're completely educated, and you can start this process of getting an estate plan in place. It is free. There's no obligation to continue. Most people do continue to write an estate plan with me, but again, there's no obligation to continue. In the first hour, we are going to look at what your plan currently is, and we're going to look at what the state's plan is for you. And I've had people after that first hour say, all of that sounds good to me, or say, as we walk through step by step, probate, that's fine with me. I don't have kids, and it's not a big deal to me if my family has to go through the court process. Okay, fine. Incapacity planning. Yeah, it's not a big deal to me. If I'm in a coma, I don't care who's making decisions for me, and I don't care how long they keep me on life support. Okay, well, if that's not a priority to you, then it's not a priority to you. There is no obligation to continue. If the current plan for you is the ideal plan, then I will actually tell you that. I'll say, it sounds to me like there's not a reason to continue here. It sounds to me like the plan that you have is a pretty good plan for you. But oftentimes there's something that people want to address. There's something in the estate's plan for you, or in the do-it-yourself plan that you've created, or the old estate plan that you've had created, that you want to change. And if you want to make a change, if you want me to help you to write an estate plan, we can do that in our second hour in the family wealth planning session. We can design the plan for you. And again, I want to give you $250 towards the plan of your choice, so that I can make it even more affordable, so that you can get that plan done and make sure that your heirs, that the people that you love, are covered and protected. So what does the family wealth planning session look like? Again, it is totally virtual, or it can be totally virtual. We get acquainted and we talk about who would be the person to collect everything for you. Who would be that person who would step into your shoes and find your assets? Is it going to be easy? Do you have everything in a filing cabinet somewhere, or do you have a spreadsheet that you've created somewhere? Is it going to be easy for them to find your assets, or is it going to be difficult? And what would happen if you became incapacitated? If you don't have incapacity documents, if you don't have incapacity planning documents in place, then there's a court process that you need to, in order to get somebody who can make healthcare decisions for you or financial decisions for you. Sorry, I'm a little distracted. I see somebody saying the special is only good for this week. Your calendar is full until mid-July. And yes, that's right. It is full until mid-July. You just need to book your family wealth planning session by the end of the week. If you're on my calendar by the end of the week, even though your actual family wealth planning session might not happen for a month or 2 months, that's okay. I just want you to take the step to get on my calendar and make sure that you reserve that time in your calendar, so that we're both planning on that meeting whenever it can happen. If it's in July, if it's in August, if it's in September. And I do just want to address, I understand that my calendar probably looks a little bit picked over now for July and for August. I limit the number of clients that I work with. And I limit the number of clients that I work with because I work everything that I do is so relational, and I take on a lot from my clients. It's a lot of work to get an estate plan in place for me, because I want to take that work off of your shoulders. So I really limit the number of appointments that I have and limit the number of clients that I'm willing to engage each month. But I do that because I think that the attention for every client is so important, and in making sure that every client has that attention and gets exactly what they need. I see intense, in-depth, and comprehensive, and it's exactly right. That's I hope that it's not too intense. It is, I want it to be relational, but yes, we're going to be going in depth, and it is going to be a comprehensive plan. You're going to be taken care of, and I'm going to make sure that I'm really passionate about this, as is probably coming through. During the family wealth planning session, we're also going to talk about what probate's going to look like for you, for your estate, and for your family. And I see, yeah, no, it's important you make sure you value your clients. It's exactly right. I do. I really value my clients, and I want to take great care of them. We'll talk about, in the family wealth planning session, we'll talk about estate taxes and whether you might owe estate taxes and how we can plan around those. And we'll talk about how you want the people that you love to receive the assets that you have to give them, how they are going to receive the inheritance. Now we can make sure that they're receiving the inheritance in the way that you want them to. I'm going to look over here and see if there are any other questions, or if there are any other chats. A lot of questions that often come up that I can speak to here is a question about supplemental needs trust. And what is a supplemental needs trust? Why do people choose to do supplemental needs trust, and what are they for? And a supplemental needs trust is for somebody who's receiving government benefits. It is very important that if somebody's receiving government benefits that pay for things like food, or for housing, or for healthcare, or mental health treatment, whatever it is, if somebody's receiving government benefits, it can be very harmful to them to receive an inheritance. It can actually knock them off of that government benefit and require that they go back and reapply and requalify for the government benefit after their inheritance is all spent and is all gone. A supplemental needs trust is a way of holding that inheritance separately so that the money can be used for things like luxuries. Maybe it's for trips to the movie theater or, special treats, ice cream, that kind of thing, trips, vacations. But the person can still stay on that government benefit and still qualify for it so that they never get kicked off. They never have to reapply. They're able to continue the way that they've been living on that government benefit, but they're also able to enjoy an inheritance that you want to give them. I mentioned kind of towards the beginning, everybody above the age of 18 should have an estate plan in place. And what did I mean by that? How many 18-year-olds out there do you know who actually have an estate, who actually have some assets that they want to pass on to somebody else? But 18-year-olds might have needs like somebody who can make financial decisions for their healthcare decisions for them if something happens to them. And many of us think, well, my 18-year-old, I'm going to be able to make healthcare decisions for them. I'm going to be able to access their healthcare records when they go away to college. That's not going to be a problem. But the reality is that oftentimes it is a problem. It's hard to get access to those healthcare records unless that 18-year-old or 19-year-old has actually waived their HIPAA waiver, their right to privacy, and have given you the ability to access their healthcare information. And it's going to be hard for you to make healthcare decisions for them if you need to, because they are no longer a minor. They're out on their own. They're an adult. And so a court is going to need to approve who the person is who's making healthcare decisions for that person. But you can step in front of that, and you can have your 18-year-old or 19-year-old create a power of attorney and a healthcare directive so that you can continue to have those abilities to make healthcare decisions for them or financial decisions for them, which is something that they probably want anyway. It's something that they probably would ask you to do anyway. Another question that I often get is, you've been talking about a living trust or a revocable trust, but I've heard about this concept called an irrevocable trust. And why would somebody want an irrevocable trust? So we were talking about a revocable trust, which means that it can be revoked or amended at any time, that you can tear it up if you choose to, which is like revoking it. You can decide that you no longer want your assets to be subject to this revocable trust. An irrevocable trust is one that you can't just tear up anymore. It is irrevocable. It's in place, and you can't amend it. You can't make changes to it easily. Okay. But an irrevocable trust can be very useful for certain things. For one, it can be very useful for supplemental needs planning sometimes. For two, it can be useful for asset protection planning. Number three, it can be useful for planning for nursing home care and for planning for the expenses of nursing home care. An irrevocable trust can also be very useful in planning for estate taxes. And there are some irrevocable trusts that we use for life insurance proceeds and other purposes that will allow you to plan for estate taxes and minimize or possibly even eliminate what estate tax liability you might end up having. I'm not seeing a lot of other questions coming through. I'm seeing somebody with their hand raised, and I'm not sure. My guess is that it's probably inadvertent. But if you're the person with your hand raised, I'd appreciate if you would. If you want to be permitted to talk, because that is something that I can permit you to talk if you want to, I would appreciate if you just tell me in the chat that you want to be able to talk. Most people do not want to be able to talk or do not want their voice projected. And so I'm pretty hesitant to unmute anybody. I don't even think that I can unmute you, but if you want to. I'm seeing somebody saying I can talk. If you want to, if you want to be permitted to talk, let me know, and I can permit you to talk. Could you put on the board what you were just saying? And is that about irrevocable trusts? And I'm not sure how I can put it. Not sure how I can put it on the board, but irrevocable trusts can be very useful for planning for nursing home costs or for planning for estate tax expenses. And so hopefully that's helpful. And I will be sending out the recording after this if you want to spend a little bit of time to go through and listen. I'm just not exactly sure what it is that you want me to put on the board here. All right, and I see, all right, Brad, you want to be allowed to talk? I will allow you to talk here. I think you're going to have to unmute yourself if you want to, but go ahead.
Hi, my name is Brad.
Hey, Brad.
I actually heard about you from my brother-in-law. We both lost sisters within the last 9 months. My wife passed away at the age of 54 last month, abruptly, and my life has just been in, like the old pinball machines where it's on tilt. My life's been on tilt ever since. My to-do list has expanded to 2 pages of really distasteful things, like trying to get credit back for the airlines for canceling her tickets, setting up estate and trust accounts, carrying a death certificate everywhere. I don't know where her assets are. I don't know how to find out. Her ex-husband was sneering at me because he has much more than that in his retirement account. He thinks I'm holding out on him. I am terrified that out of his abundance, he's going to come after my little. I don't know how to demonstrate to him that this is what there is, because I don't know.
Yeah.
And she was the center of my life. She wasn't just like somebody I knew or whatever. I came to Minnesota from 1,000 miles away. She befriended me, and then loved me when I had nothing. And my life has revolved around hers since we met, really. And now to have her gone, I'm just like rudderless. I don't know what's going on. I
have a trust that's not favorable.
Yes, I have a trust that's problematic, that I didn't really understand much, but she was a financial professional. She had an MBA and had a heavy duty accountant job. She was a CPA. I just let her steer me. So we have this trust now that I'm not even really sure that I understand what it means. And I also realize now that I made it way too hard for my kids to inherit. And that was a big screw up because I didn't know what I was doing. And I'm really glad to have sat through this presentation with you, but that's kind of the quick description of my issues. I've been so upset. And this is exactly not the right time, to have your world coming to an end.
Right. Yeah, I hear you, Brad, and my heart goes out to you. It's a tragic story that you're sharing with us here, and what I'm also hearing from it is, at this time when you're grieving and you really need to give yourself the space to grieve, you are trying to put financial pieces together that are complicated, and that there are a lot of dynamics to that you don't completely understand, that you're not completely comfortable with. And again, my heart really goes out to you that you're having to go through this right now, and you really should just have the space to grieve and to give your space there. I see you didn't even have life insurance for her. We just paid $5,000 for a trust last year. Yeah, this is again, that's a tragic story. It shouldn't be like that. It shouldn't be like that where you aren't completely educated and have a complete understanding of the trust. You should have that. After working with an attorney, you should have a complete understanding of the trust, and that attorney should have helped through this in order to get everything squared away. But I'm really glad that you're here tonight. I'm glad that you've been able to educate yourself about this topic, and I hope that you'll let me know if there are ways that I can help, and I'd be happy to do that. So thank you for sharing, Brad. Booked. Fantastic. Good. Thank you. Well, I don't see any other questions here. Again, thank you, Brad, for sharing there. Thank you, everybody, for the questions that you brought here tonight. Again, I really encourage you to get on my calendar. I would love to help you. I would love to help you get your affairs in order and to get things figured out for your family. I'm really passionate about this, as has probably come through again in this presentation. And I'm available if you have questions over email, or if you have questions over phone, that you should be able to reach out to me. and get those questions answered. I'm going to go ahead and end our presentation here today. But again, I just want to thank everybody for joining me. I want to thank you for educating yourself about this topic. And I want to wish you a very, very good night. And I hope that you have a good evening. Take care.